Hi, so the topic that I have chosen to write about is the death penalty for juveniles. My name is Deania Garner, and the proposed question to be answered in my research is the death penalty for juveniles an effective deterrent for heinous crimes? This question will be answered at the end of my presentation. A fun fact is that death row inmates in the United States typically spend over a decade awaiting execution. Some have been on death row for well over 20 years. The history of the juvenile death penalty in itself is very interesting. In the 18th century in America, juveniles as young as 7 years old could be tried and sentenced in criminal courts. The first juvenile court was established in Cook County, Illinois in 1899, but it was not until 1925 that 48 of the 50 United States had a juvenile court system. It was not until 1990s, with an increase in juvenile crime, that almost every state passed laws to try juveniles in adult criminal courts. And it was not until Kemp v. United States in 1966 that determined that juvenile offenders are entitled to the same amount of due process as adults under the juvenile court's jurisdiction. With such a strong history, one would wonder who the foundational victims for the death penalty were. So first we have Thomas Granger, who was the first documented execution in America of a child offender. He was only 16 at the time of his hanging, and in 1944 there was George Siney Jr., an African American who was arrested and electrocuted for allegedly murdering 2 white girls in South Carolina. This was significant because he was only 14 and his jury was all white, and it took 10 minutes to find him guilty, and his lawyer did not file an appeal. What are the many ways that one can be executed? Well, the primary method of the execution in the United States is by lethal injection, but there are other methods. After the abolishment of juvenile death penalty sentences, there was 22 inmates executed as juveniles, or executed for the crimes they committed as juveniles. The concern that most people like myself do not realize, the cost of killing someone on death row. The majority of these costs occur at the trial level. For example, in Texas, a death penalty case could cost an average of $2.3 million, and about 3 times of that cost of imprisoning someone in a single cell at the highest level of security for 40 years. There are 3 significant cases in the juvenile death penalty history. The first is Thompson v. Oklahoma. The second is Stanford v. Kentucky, and the third is Roper v. Simmons. These 3 cases all question the validity of the death penalty against juveniles and the 8th Amendment's prohibition against cruel and unusual punishment. In 2005, the Supreme Court in Roper v. Simmons struck down the death penalty for juveniles. 22 defendants had been executed for crimes committed as juveniles since 1976, up to the Roper v. Simmons case. The aftermath of Roper v. Simmons was, although 20 states had death penalty provisions for offenders aged 17 or younger, when Roper v. Simmons was decided in 2005, few applied those provisions. The courts and jury handled death penalty cases as all other juvenile cases. They were very hesitant to impose death on juveniles, and there was an 85% reversal rate on all cases where juveniles were sentenced to death. How does a court know whether punishment is cruel and unusual? Well, the 8th Amendment of the United States Constitution states that cruel and unusual punishment shall not be inflicted. This means that any individual convicted of a crime has the constitutional right to be free of cruel and unusual punishment. This is the basis for any criminal sentence, and it is said that if one violates basic humanity or dignity, it is clearly inhumane, and it may be considered cruel and unusual. So, is it unusual death penalty for juveniles? Yes. So, it is highly unusual for now, in 2017, for a juvenile to receive the death penalty. Only one state, Texas, still allows for juveniles to be on death row. Texas, Virginia, and Oklahoma together make up 82% of all United States executions in the last 25 years to date. A common liberal position on juvenile death penalty is juveniles have not fully developed character, and a conservative would argue against that, saying the punishment should fit the crime. It does not matter. It's arbitrary. As you can see from the graph, 69% of Americans oppose the juvenile death penalty to begin with. So now that we know Americans' majority oppose juvenile death penalty, you would wonder what the international opinion is. Well, the ultimate goal of the international community is to abolish totally the death penalty under all circumstances. However, until that time, there are restrictions on the categories of persons who can be executed, juveniles being one of the restricted categories. So why do they commit these crimes in the first place? Well, most juveniles commit crimes for various reasons. Research shows that abusive childhood experiences can trigger violent behavior, and a researcher, Dr. Crocker, wrote that the nexus between poverty, childhood abuse and neglect, social and emotional dysfunction, alcohol and drug abuse, and crime is so tight that in the lives of many capital defendants as to form a kind of social historical profile. Dr. Mallet completed the most comprehensive study of traumatic experiences in the lives of death row juvenile offenders to date. He found that 74% of juveniles experienced family dysfunction, 60% were victims of abuse or neglect, 43% had a diagnosed psychiatric disorder, 38% suffered from substance addictions, and 38% lived in poverty. More than 30% of all these death row inmates, juvenile offenders specifically, had experienced 6 or more of these distinct areas of childhood trauma. In the next few slides, I will demonstrate the growth in violent crimes committed by juveniles, where they are normally and previously have been accused and sentenced to death. So, about 95% or more experience at least one of the listed abuses or experiences. The most common is physical, sexual, and psychological abuse. Well, with the heinous and violent crimes that typically lead to death row trials for juvenile inmates, you can see that murder in 1994 and 1995, there was a peak in arrests for murder charges in juveniles. Some identifiable trends on the data table is the steady increase from 1987 to 1994. Then suddenly there was a steady decrease. In 2004, the rates remained at an all-time low. As you can see from the graph above, there was a peak in 1991 for arrest of juveniles convicted of rape. The arrest rates were then increasing from 1980 to 1991, but slowly began to decrease over time, but not as much as the decrease compared to murder. As you've seen above, you will see there is a peak in arrests for robbery in 1994. There then was a steady increase until the mid-90s, but began to decrease as soon as the 2000s approached, but by 2014 there was a 69% decrease in arrest rates for robbery. In correlation to robbery, aggravated assaults peaked in 1984, with a steady increase in the mid-90s, but there was an all-time low in 2014 that soon decreased by almost 50% since 2005. So to conclude my research, the death penalty for juveniles is not a reasonable deterrent for the crimes they commit. Based on Dr. Mallet's research, mostly research of the adolescent brain, as well as statistics from the Death Penalty Information Center and the Bureau of Justice Statistics, juveniles are not mentally capable of recognizing the consequences of their actions, nor will they understand that their life will be ended because of it. It is, in my opinion, as well as the Supreme Court's, a violation of the 8th Amendment, which states that in no way should anyone undergo cruel and unusual punishments, especially if they are incoherent, meaning too young. Their brain hasn't developed. I believe that children are completely incoherent during the crime and after. Although it is abolished by both internationally and nationally because of Roe v. Simmons, there are still challenges facing the death penalty. We do not know the current economic ramifications of the death penalty. It is really the best protection, or a question is it really the best protection from a murderer? Are the methods reliable and practical? And if so, why are there backup methods of execution? Did the victim really receive justice after a person dies? Or, we just don't understand. So we still have these challenges, and through further research and discoveries, these questions can be answered, but the answer won't stick because times change. Thank you, and have a nice day.